A very good evening to respected Professor K.D. Raju and all the other learned participants who joined the Google Meet, and my team members, Dr. Irfan Abbas, Mr. Srinivas Rao, and Mr. Nagaraju, Ms. Vaishnavi, and other friends. And I have great pleasure in inviting you all to the 16th online lecture in the series called Know Your Intellectual Property, launched by the DPIIT IPR-Chair, Osmania University. And we have had the privilege of hosting some of the best brains in the field of intellectual property rights so far. And today, I am really grateful to Professor K.D. Raju for joining us in spite of his busy schedule. The resource person of today, Professor K.D. Raju, who will be speaking on the interface between intellectual property rights and competition law in India. He doesn't need any introduction, in fact, because I also followed his book on intellectual property rights, a very comprehensive presentation and on various aspects of IPRs at the national and international level. Professor Raju is at present a professor at Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur, and previously he, in fact, acted as the Deputy Secretary, PhD, Chamber of Commerce and Industry, New Delhi, Assistant Director and Lecturer at Amity Institute of Global Legal Education and Research, New Delhi, and he also worked with the civil society organizations like Oxfam, and he began his research career with M.Phil studies at Jawaharlal Nehru University, New Delhi on international law, and further his doctoral studies at JNU in international trade and economic laws. And he has been awarded the prestigious Fulbright Scholarship by USEFI, that is United States Education Foundation in India, for completing his doctoral studies at the University of Illinois, Urbana Champagne, United States. And he has been awarded with the Microsoft Outstanding Young Faculty Award in 2011. Sir has more than 20 years of experience and has published 8 very well received books on intellectual property rights, including 4 exclusively on intellectual property rights, published several book chapters, number of articles in national and international journals, and he also participated in number of national and international seminars and workshops. And apart from that, he has taken up number of consultancy projects for both the government as well as the private organizations, and also offered the courses on international law, WTO law, then International Monetary Fund and World Bank, and IP and competition law, so on and so forth. And he has a very strong command over international law, competition law, intellectual property rights, and the interface with the intellectual property rights. I don't want to stand between Professor Raju and all the learned participants, but only one important aspect is that Sir will be probably, in fact, demystifying many of the issues relating to the abuse of dominance and under the competition law and the interface with the intellectual property rights, which makes a very interesting, study and observation. Sir, these are the participants from different backgrounds. Many of them are IPR teachers and teachers of the allied subjects. Some of them are research scholars. Some of them are even teaching the other related subjects. Some of them are practicing advocates. It is an amalgamation of, in fact, a wide variety of backgrounds. But one thing is certain, sir, any Saturday during the last 4 months at 5 o'clock, majority of them are present in spite of their busy schedules. That shows their enthusiasm to learn more and more. With these few introductory observations, I cordially invite Professor K.D. Raju to make his presentation on interface between IPR and competition law in India. Over to you, Professor.
Thank you, already, sir. I think when we met in Delhi, so I told him very clearly that yes, definitely I would like to join. And first of all, I congratulate Reddy sir and his team for organizing a series of lectures on intellectual property law. So because when we, in some meeting, we saw that, so we were asked to assess the intellectual property knowledge of, the people in the country. And we were, examining them, and we saw the lack of clarity on the subjects, on various subjects of intellectual property law among the scholars and also the students. And so the sir was invited me, so immediately I accepted his invitation. So, so when we look into the competition law, so competition law is the countries like developing countries like India, it is very new, but the countries like US, it is very old. It is not in the name of antitrust law. So I will start with the famous economist, the Adam Smith, so who is considered to be the well-known scholar who wrote The Wealth of Nations, the classic. I would say that this is the classic epic book which he wrote. He wrote that people of the same trade can seldom meet, even for merriment or diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices. So this is against the market. So I think even in 1857 itself, so this is they were talking about if somebody is conspiring against the market forces, then it has to be cut. So because it is against, so if anybody is conspiring to make monopolization, and that is against the welfare of consumers. So you can see that the history is starting from US. So, but definitely my presentation is absolutely focused on the Indian side because of the time constraints. So if you look into the historical background, we can see that this Sherman Act was passed, against trust, those who were completely monopolizing the trade. So the Sherman Act, we can say that is one of the first modern law to curb this kind of monopolization. That is why the name of the act itself is antitrust. It was against the trust who made a lot of amaze, lot of wealth at that point of time in that country. But when it comes to the concept of intellectual property, but everybody says that intellectual property is new, but I would say that intellectual property is not at all new. Intellectual property is, we can see that it is, we can very well see that it is, emerged long time back. So if you look into the historical background, I have, the first chapter of my book itself, I have explained the complete history. So we started with, the first patents which are granted in England, as well as in US as well. So the history says that the first patent was granted in 1449. So our knowledge is that this is a very bad area of the scholar says there are two sides of the scholar says that intellectual property rights are private rights. So some scholars are against it, the private rights. But we can see that the first patent was granted to John of Udine in 1449. So he was awarded at that point of time 20 years monopoly for a glass making process previously unknown in England. So you see what is the coincidence. 1449, somebody got a patent for 20 years. And now under the TRIPS agreement also, the protection of patent is 20 years. So this may be quite coincidence. And then later on in US, we can see that in 1790, the first patent was granted to Samuel Hopkins of Pittsford, Vermont, and for a particular device. So for special process of making candies and other for improved flour milling machinery. So we can see that these monopolization for a limited period of time, I would say that it's for a limited period of time. Definitely it is an incentive. So the incentive theory is very prominent for the justification of protection of intellectual property law. Definitely the creation of mind, if the creation of mind innovation, so there must be some kind of incentive to be there for further innovation. So the incentive theory is very prominent for as a justification of the intellectual property rights protection. And now it's with we can see that the Paris Convention for the Protection of Industrial Property, 1883, one of the first which protects the patents, intellectual property. Then later on, Berne Convention for the Protection of Literacy and Artistic Works, 1886. So we know that still these particular provisions of Berne Convention is applicable in the case of literary and artistic works, and most of the countries enacted copyright laws. Then later on, the Madrid Agreement comes in 1891, and the Madrid Agreement protects something which is originating from some particular areas, and now we call it as geographical indications. And in Europe and other places, it is known in other different names. So basically, we can see that it is the countries, those who protect intellectual property, it is not very new. Now, all these laws, whether it is the Paris Convention, or it is Madrid Agreement, or it is Berne Convention, now all these are consolidated into the TRIPS Agreement. And TRIPS Agreement, I would say that now the TRIPS Agreement is the Bible of intellectual property law. So the intellectual property, the importance of this intellectual property law or the TRIPS Agreement is that 164 countries are member in the TRIPS Agreement. So India is a founding member. 164 countries, which constitutes 99.9% of the world trade. That is the importance of this TRIPS Agreement. So at least these minimum 164 countries has to enact a law to protect intellectual property at the domestic level. This is the TRIPS commitment they have to make. There is no other choice. But when it comes to the competition law, as I told you that the competition law is very prominent in other countries like the US, but it is not very prominent in the developing countries. Not at all very prominent. So it is a new concept. The competition law is a very new concept to countries like India or Brazil or other countries. But we can see that by 2022, so I was searching that it is saying that around 120 countries, more than 120 countries have competition law as well. So it shows the importance of competition law as well. So 164 countries have these intellectual property enactments. More than 120 countries have competition law enactments as well. Because this shows the curtailment of, so monopoly power versus market powers. So everybody knows that. So everybody says that the intellectual property law versus competition law. I'm never going to say intellectual property is or competition law is against intellectual property law. I would say that both these legislations supplement each other or supplant each other. And if a monopoly power is given to a limited period of time, if the intellectual property holders, owners, or licensees are found to be misusing that particular monopoly power, then the competition law is going to visit that particular incident and the courts are going to take a decision. So here, the objective of competition law is very clear. It protects the competitive process, not the competitors. And also, it clearly says that it is looking only into the economic efficiency of the market, not the competitors and per se. So harmful effects, wherever there is harmful effects of monopoly, and then if the consumers are affected, by high prices, no choice, or there is cartelization, or it is time agreements, whether it is vertical agreements or it is horizontal agreements, then the competition law is going to visit that particular incident. So you can see that most of the companies, definitely they are trying to monopolize, or even though they get the monopolization for a period, they try to extend it through different means. So there, the role of competition law comes. So here, as I told you, the prominent perception is that the IPR is a monopoly. It is not forever. So IPR is for a limited period of time. So competition law mostly disagree with monopoly. So, and also, but the intellectual property rights boost the spirit of inventor. So to what extent it boosts? Definitely it boosts because there is an incentive. is for the limited period of time. And competitive at the same time, we have to see the market competitiveness of this particular product in the market as well. Whether these are monopolizing or whether these are misusing the monopoly in the market. So we can see that always, I would say that the intellectual property rights protects this technological innovation. And competition law encourages competition in the market and stop the abusive practices in the market. So I have just given you a representative. So the benefit of competition, everybody says that there is choice in the market. So the monopoly rights reduces choice in the market. So the best example is the Indian car market. If you once upon a time, you have only one ambassador and probably another a small car that is the premium. And now there are beautiful foreign cars in the Indian roads, which you can see one of the best example of competition in the market. Quickly, let me see, go through the TRIPS provisions. If you look into the TRIPS various provisions, you can clearly the TRIPS permits the members to adopt IPR laws. At the same time, these provisions very clearly says that to see that IP provisions are not abused. There should not be a negative impact on the market at all. And it permits the members to adopt measures against practices, and which include exclusive grant back provisions, coercive packaging licensing, etc., etc. So we are going to see that most of these, the provisions which affect the market in the later part of the presentation. So competition and innovation, I would say that it is not only the intellectual property increases, intellectual property innovates. So the protection of intellectual property innovates. I would say that the competition stimulates innovation. So if competition in the market, if there is no competition, as again, we can see the example of the car itself. If there is no competition, there was no innovation for the ambassador car. So the ambassador car has disappeared from the Indian market now, because there was no competition once upon a time, so they were not innovating. So now there is a competition in the market, so they disappeared. So the competition definitely increases the invention of new products. I would say that efficient products. So competition, only the competition can increase competition in the market. So the competitive process is not. So if you're not encouraging the competitive process, there won't be any competition in the market. So is any philosophy, it says that the competition definitely encourages innovators. I would say that competition is a strong incentive for innovation. So intellectual property is less incentive for innovation. So people may agree or people may not agree. So we will see where is the interface. So now we saw the intellectual property as well as the competition law. Now, where is the interface? Definitely interface, as I told you, that all competition law provisions, excluding intellectual property protection, because intellectual property protection is only for a limited period of time. So the intellectual property provisions are excluded from the purview of competition law provisions. But the competition law provisions is applicable when there is the intellectual property rights are abusing the market power. So there are various ways we will look into this clash, the so-called clashes between intellectual property and competition law. And as I told you, I would always argue that there is no clash. Only both the provisions, these are the tools, intellectual property law and the competition law, they promote competition in the market. I think we will little bit go ahead. And if you look into the, I have just given, I told you that, because of time constraint, I am not looking into the US jurisdiction or EU jurisdiction, but we have a lot of jurisprudence from these two jurisdictions. If you look into the Europe as well as in the US, so we can see that there is a strong competition laws, it works, because we have a lot of cases, the famous cases, like the Microsoft cases, IMS Health cases, the latest cases like Google, Huawei cases, and a number of cases which talks about the various, provisions, violation of the various competition provisions in these particular markets. And we can see the divergence as well, because the famous Microsoft case in US and as well as in European Union, that is, I would say that the cornerstone or the turning point of the IP versus competition law discussion. Because you can see that the European Union and the competition authorities imposed a grouping, the penalty of US around $731 million. $731 million imposed fine on violation of IPRs by the competition authorities. At the same time, the Microsoft case we can see in US is settled. So we can see the different approaches. So European Union has imposed a heavy fine. In US, it is they settled the matter between Microsoft and the competition authorities. And what was the settlement? Nobody knows. What is the amount which is involved in this particular settlement? I think probably everybody heard about this Microsoft case in US and EU, but nobody heard about the Microsoft case in India. So I'll see in later part this particular case as well. And when we look into India, and we can see that the Micromax case is the watershed, what I would say that the cornerstone of the whole discussion between IP and intellectual property law in India. And also this was the Micromax case, Micromax versus Ericsson, or Ericsson versus Micromax was the first case where the essential patents were discussed by the Delhi High Court in this particular case. So, and also we can see that in another case, in Google and Motorola cases, so Indian courts were very liberal in granting injunctions in support of these multinational companies. In European Union, it is very difficult to get an injunction against the particular abuse of the competition provisions. But in India, it is liberally granted by the Delhi High Court. Whenever a multinational company approaches the Delhi High Court has liberally granted injunctions. We will see these cases on the later part. So, as I would say that the discussion between competition law versus intellectual property, it is very clear that there is common objectives, but the IPRs cannot be used as an excuse for the curtailing competition in the market. Let us directly go to the Indian scenario where what is happening in India in this particular case. So everybody knows that the market performances are the key to the competition in the market. So if you look into the Indian scenario, I have mentioned that, so Indian scenario, if you look into the competition, it is very closely related with trade in the sense that international trade. So if the moment I would say the international trade, so it is starting with the, much before the colonial period. So the history says that in 1498, the first person landed in this part of the country. So the southern part of the country, that is the Portuguese traveler, the well-known, everybody knows about Vasco da Gama. Vasco da Gama reached the port in the present Calicut or Kozhikode, the present Calicut in the state of Kerala. So he came with an agenda, and that agenda was trade. But when the Dutch came, Portuguese came, then the Britishers came, yes, the competition increased. So the Britishers tried to send out other people. So I would say that because in order to reduce the competition for the raw materials or the spices which they are collected from that part of the world. So always, as I told you, that every trader, every company, every multinational company tried to monopolize the market. So they sent out by 1600, they sent out all the players from India, and they have become the monopolies. So that is international trade. That's why I said international trade is very closely connected to the competition, and how the competition law connected with intellectual property law we are going to discuss. As I told you, the IP always creates monopoly, but the competition battles monopoly to some extent and in certain circumstances. So as I told you that as a perspective, Indian perspective, as an India, as a developing country, so how we are going to see this, this India scenario. So we can see that the competition law, the competition law mainly look into, I think the Reddy sir was already talking about, our competition law talks about abuse of dominant position and also, fighting anti-competitive practices. So we can see that the anti-competitive practices in the form of exclusive licenses, licensing restrictions, refusal to deal, time agreements. So all these are mentioned under the Indian Competition Act 2002. And at the same time, we can see the other abuse of dominant positions as well, which see a series of other anti-competitive agreements like combinations, mergers, and predatory pricing, etc. So if you look into Indian competition law, is very clearly says, but I don't want to, the historical aspect of the competition law. I think probably as a student of law, everybody must know the historical aspect. So we don't have, after the post-independent India, we don't have a competition law. And the various committees were, the appointed by the government at that point of time. Then finally, so we know that there is another committee which was looked into the anti-competitive practices, or we can say that industrial licensing policies and the license Raj system at that point of time, which is prevailed. So the Hazari committee was very popular at that point of time, and which they later, so they found that the concentration of wealth in India is very high. So you should enact a law. And that is why we got the Monopolies and Restrictive Trade Practices Act, that is the popularly known as MRTP Act. See, MRTP Act was in place for 33 years. 33 years that was ruled in the country, but monopolies are increased, but not decreased. Or the concentration of power has increased, not reduced. Then comes the concept of competition in the market, the competition law in the market. And definitely the Raghavan committee has, played a crucial role. And finally, we passed the Competition Act 2002. So for a long period of time, because of the interference of the Supreme Court of India in one of the cases, so everybody knows about the Brahmadat versus Union of India 2003 case. Up to 2007, it was in the cold storage. So we were not able to implement the competition law. So then 2007 itself, so we can say that in 2009, we can say that this particular case was resolved and the Competition Act, some of the provisions were notified. So the Competition Act came into place, and the Competition Commission of India, the most important institution in the country, has looking into or inquiring into or investigating into this particular abuse of dominant position and anti-competitive practices. So Section 3 very clearly says that the enterprise or associations of enterprises cannot, the persons cannot enter into any illegal agreements for production, supply, distribution, storage, acquisition, control of goods or provisions of services likely to cause an appreciable adverse effect on competition. This is the language which is used. It is very interesting to see that appreciable adverse effect on competition. This is the language which is taken from the European, the European law or European directive, appreciable adverse effect on competition in India. And appreciable adverse effect on competition is also explained in various provisions in the competition law. So this provision along with 3.5. So 3.5 very clearly says the competition law does not going to affect the intellectual property rights. And also Section 4 says that it restrains the IP holders to abuse their dominant position if they misuse the dominant position. So it is very clear under Indian law, Indian competition law also, even though the IPR is exempted, but if anybody is misusing the dominant position, then the competition law can definitely interfere. So one of the, I thought that let me present all the cases which involves IP and competition law in India. We have very, it is around 20 cases, but some of the cases we will discuss. And these are the very beginning cases, okay, in the FICCI Multiplex Association, Amir Khan cases. And also you can see that Micromax, which we are talking about, and we have some of the aspects where in Kingfisher and Halfkin Cookies, Entertainment Network India Limited. These were some of the very beginning, 2000, that means 12 years back cases. And we will see some of these cases, elaborately what was happened. For example, in the case of Amir Khan Productions versus Union of India. And this is, I would say that this is the landmark judgment in India with regard to IP and competition law. So the entire Pandora box is opened with the Amir Khan Productions case. So this particular case, so a clear demarcation between the extent of intellectual property rights and competition law intervention, and also in innovation in high technology areas. So some of the provisions were clarified by the courts, especially the Bombay High Court and Delhi High Court. And there are a number of cases in Delhi High Court, mostly interpreted the provisions, various provisions of whether it is Copyright Act or it is Patent Act. So here you can see that the question is, if theatre owners are going with their monopoly activities. So if the distributors going with their monopoly activities, if somebody is not giving their cineplexes for screening various the movies, or if some of them as making tying arrangements, okay, you have to take this particular movie, so this production house is going to make 10 movies or 5 movies per year, so you can have a contract for all 5, not 1. So these kind of tying arrangements, cartel arrangements are discussed in this particular case. So the court, it's very interesting to see that the court said that copyright, yes, everybody. So we heard from our intellectual property classes that copyright is a bundle of rights. Yes, this bundle of rights, but the court said that this bundle of rights are not absolute rights. So the competition law will visit if somebody is misusing this copyright in the name of copyright. If somebody is misusing these provisions in the name of copyright. So you cannot have the unilateral imposition of any license agreements on the theaters in India. I'm talking about this particular case. So the court very clearly said that yes, copyright is an intellectual property right for a limited period of time. There is a prescription, but it is not, these bundle of rights are not absolute rights. So it talks about some of the provisions of this Copyright Act. Yes. So with regard to the cinematograph films. So these particular provisions confers, yes, definitely certain rights on the owners or the assigned persons. So at the same time, if a complaint is made to the copyright board by the owner of talking about some films, so then definitely the copyright is with the owner, but definitely they cannot make unilateral imposition of license agreements on the multiplexes. So in this case, it is very interesting to note that the American productions were imposed. So the court has imposed 1 lakh rupees fine on American productions. So I think probably it is the first time that in such kind of cases, the intellectual property versus competition law, a fine has been imposed by the court in this particular case. So then later on, the court has clarified. That the copyright is not an absolute right in the famous super cassette case as well. At the same time, you can see that the legal aspects in the case of certain the patents, in the case of the patent poolings, refusal to license, and other anti-competitive practices which the IP holders, which usually they take out. So these are the violation of the competition provisions. And I would say that another watershed case in India is the Micromax versus Ericsson, because in this case that the court said that the first time it said that the Delhi High Court again said that the Competition Commission have the jurisdiction to investigate into an intellectual property involved competition law case. So the high technology areas, now we can see a big fight between the multinational companies and small domestic companies. So Micromax, everybody knows that that was the handset making company for mobile, the services, handset making company, Micromax, which won some of the licenses for 2G, 3G, and 5Gs from the Ericsson, the multinational company which holds the licenses, which hold the patents for these particular technologies. So the Ericsson was quickly approached the Delhi High Court, and the Delhi High Court was very liberal in granting injunctions against Micromax. So as I said that in other countries like the US and European Union, the injunction, granting of injunction is very sparingly used in IP versus competition law cases. But here the Delhi High Court is very liberal in this particular aspect and granting injunctions in favor of the multinational companies, not looking into the poor situation of the domestic companies, those who want a license for these particular technologies for a lower royalty rates, because most of these Ericsson-like companies ask for a huge royalty rate. So the court never looked into the what is the royalty rate, whether it is a front terms, whether you get it for fair and reasonable terms. The front terms, the court never looked into. At the same time, so once, as I said, that this was one of the cases where the first cases where the essential patents were discussed by the court in India. And that particular category of it was first time discussed in India on this particular case. And also we can see that if somebody is refusing to grant a license, what he will do, and that also an essential technology is very essential for the working of the new technologies like the telecommunication technologies like 3G or 4G. So what he will do? So definitely, that is why in other countries, the once you declare a particular technology on front licensing terms, so you have to license it for reasonable royalties. So these particular reasonable in inverted commas will change from place to place. So the United States, you may charging one royalty. In European Union, maybe another one. In China, it may be a specific royalty, but you cannot impose that particular standard to India. So because India is a developing country and the special situation to be taken into consideration for determining the royalties. But the Indian courts, I would say that the Indian courts are failed to look into this particular aspect, that yes, you require the technologies, new technologies, for a reasonable, fair and reasonable terms. But what is that fair and reasonable terms? In none of the cases they were decided what do you mean by exactly what is reasonable royalties. So see, standard essential patents are another category of the jurisprudence raised in US and European Union. And they have clear guidelines with regard to standard essential patents. But the problem in India is we doesn't have a standard on standard essential patents in India. But if so, this particular almost I think that for 10 years these two companies fought each other, and finally the Micromax and Ericsson settled the matter outside the CCI, but the complaint is still pending before the CCI. So they settled the matter outside the CCI, outside the court, because it is going for a long period of time. So again the question raises, the Micromax cases raises the question that whether our Competition Commission of India have the experience to deal with this particular kind of cases. I was talking about the Microsoft case in India. So everybody know about the Microsoft case in US and EU. So the Singhania and Partners LLP versus Microsoft Corporation Private Limited. So this particular case is decided in India. So this is the Microsoft India case. So usually we know that if you purchase one license of Windows, yes, the single license will be more price and the volume license will be less price. But here you can see, it's very interesting. So the Microsoft said that the original equipment manufacturer's license, the volume licenses are, we charge much higher prices, the volume licenses, than the single licenses which we are giving it to various concessions to students and other people. So the Singhania and Partners where LLP was trying to it's a KPO, so LPO, and they were purchased these particular, they want this licensed the Windows 2007 at that point of time. So they saw that the prices are very high, higher than the market prices which was charged by the Microsoft. And remember, still the Microsoft holds more than 90% of the Indian market of OS, operating systems. And hardly there is 10% of the open source softwares are used. So the argument of Singhania was that the India Microsoft is in the dominant position and they are abusing this particular dominant position in the Indian market, and also violation of various provisions. So here, the Competition Commission of India and doesn't find any violation of any of the provisions of the Indian Competition Act. I really surprised to see that the similar circumstances, similar cases in United States, European Union, there is a heavy fine on the Microsoft. India, the Competition Commission said that there is no evidences to show that the Microsoft is abusing dominant position in the Indian market. So no action. So I would here, want to say that there is one member of the Competition Commission of India at that point of time is Mr. R. Prasad. So he has dissented the majority opinion and said that yes, the Microsoft is doing anti-competitive practices and also abuse of dominant position in the Indian market. I would like to join with Mr. Prasad. Very clearly said that similar circumstances, similar provisions by the Competition Commission of India doesn't find any violation of any of the competition provisions in India, but the US and the European Union found violation of these provisions. So I thought that all the cases which is relating to the standard essential patents, now most of the fight in intellectual property versus competition law is going on. So there are in the case of there was in Ericsson versus Micromax case, there was allegation of time, bundling, pooling. So all lot of allegations under so all these are the violation of the Competition Act. So CCI has actually ruled against Ericsson. So the fixing the royalty was the only question, but we can see that there are all these were raised by the parties in this particular case and licensing terms. And the CCI found that yes, the Ericsson was violated the FRAN terms. So once you are declared this as essential patent, or this we can give it in on FRAN terms, and they have to give. So the royalties, the excess royalties cannot be asked by these particular companies. So, but the Ericsson on the other hand has argued that the CCI, the Competition Commission of India, doesn't have the jurisdiction to deal with these cases. So, but the Delhi High Court has very clearly said that there is no conflict between competition law and patent law in India, because these two legislations are operating in different places or different spaces. So I would like to quote from the order. I quote, if there are irreconcilable differences between the Patent Act and the Competition Act insofar as anti-abusive provisions are concerned, the Patent Act being a special act shall prevail, notwithstanding the provisions of Section 60 of the Competition Act. In absence of any irreconcilable conflict between the two legislations, the jurisdiction of CCI to entertain complaints for abuse of dominance in respect of patent rights cannot be boosted. So the court, if you look into these words, the court Delhi High Court very clearly said that Competition Commission have the jurisdiction to deal with IP involved competition cases. So in another case, in 2018 case, if you look into the standard essential patent case, which was discussed in Rajesh Mensah case. So here also we can see that the Phillips versus Rajesh Mensah, in this particular case also, is very clearly said that the court has rejected the argument of the Indian side and said that the plaintiffs has filed a suit against the defendants on the ground that their decoding device, so standard essential patent, had been patented in India in 1995. So it is infringement. Actually, it is not IP versus competition law, so it was an infringement case. But the court held that the local manufacturers are clearly infringed the patent of Philips. So the Philips got the judgment, and the court said that there is no abuse of the dominant position by the films in the Indian market. So honest right, then in the case of refusal to deal, I think the FICCI Multiplex Association versus United Producers. So again, as I told you, was the UPDF, the United the Producers or Distributors Forum. So they copyrighted film, and also there is the problems of screening movies in theaters. So here also, as I said that, they very clearly said that the copyright protected films, the CCI have jurisdiction to deal with this particular kind of cases. So as we know that the copyright owner, yes, they have the rights and they have the absolute rights. The question is again, there is no absolute rights when the competition law is going to meet with the intellectual property protection. So as I told you, the court in the Microsoft case, United States Microsoft case, and the US court very clearly said that copyright does not give its holder immunity from law of general applicability, including the antitrust laws. So Micromax and also the FICCI Multiplex cases, the Indian court also followed the jurisdiction, the judgment in the US courts. Yes, the copyright does not give its holder immunity from laws of other applications like the competition law. So the competition law is applicable to the intellectual property involved cases. So if you look into the Indian Performing Rights Society versus Eastern Indian Motion Pictures also, you can see that the cumulative reading of copyright, so definitely it is a statutory right, but the Indian court said that it is not an absolute right. So as I said that in Super Cassette case, also this very clearly said the copyright is not an absolute right in India. So if you, I think probably we will skip this particular case on spare parts and we will come to some of the other important cases like, yes, this Mrs. Etos Worldline India Private Limited versus Verifone India Sales Private Limited. So here very clearly the court said that this is the question of restrictive conditions in technology transfer agreements. So technology transfer agreements are one area where the multinational companies put restrictive agreements like trade back provisions and also the grant back provisions and also the intellectual property grant back provision which they usually put it in these agreements. So the court said that yes, restrictive conditions for technology transfers or service agreements imposed upon other parties with a higher market share, whether it is 70 to 80%, is the violation of Indian competition provisions. So I already said that the Competition Commission has looked into the licensing agreements. So if you look into the licensing agreements or product licensing agreements, so you cannot put restrictive anti-competitive conditions when you are entering into agreement with the Indian producers or Indian licensees. At the same time, if you look into some of the 2016 cases, so online payment technology using and Just Tickets Private Limited versus Big T Entertainment case or Vista Entertainment cases. So if somebody is providing a standard essential patent case, here also you can see that if somebody is holding the standard essential patents, yes, it is the duty of the standard essential patent holder to see that it is licensing to the Indian part or Indian collaborators or Indian licensees for a reasonable royalty. And I think almost around 20 cases were filed against Monsanto. So Monsanto Mahiko, everybody knows that it is a collaboration of a multinational company and an Indian part. Yes, Mahiko is an Indian, the Maharashtra company, as well as the Monsanto group. So they formed a joint venture that is the Mahiko. So this company there is a lot of allegations against Monsanto. I am not entering into the allegations or the controversies. But here also, if you charge high prices, unfair prices for a patented technology, whether it be maybe BT cotton or it may be the patented seed technology, and if you insist for exclusive supply agreements, if you are refusing to deal, and the Monsanto claimed an IPR exemptions under the particular provisions of the Competition Act. So the decision is pending a series of cases. I am very sure that the Competition Commission is going to held against Monsanto. You cannot refuse. You cannot refuse to deal with anybody. You may not like me, but you cannot refuse to deal with me. And I guess definitely there can have exclusive supply agreements, but you cannot put restrictive conditions in the supply agreement. So we are expecting some of the decisions in these particular cases. And Best IT World is another case, again, the Ericsson, against the Ericsson. So again, some of these cases are the allegations of infringement. These multinational companies go against the Indian companies threatening infringement suits. I would say that infringement suits are only, a threatening tool, used as a threatening tool to the Indian companies for, claiming damages. But actually, the Indian companies asked for, licensing. The technology is licensed to these companies on front ends, and the multinational companies mostly doesn't respond, or they will fix the royalties on a very high rate. So there must be, yes, I would say that there must be some guidelines with regard to these front ends or the royalty rates. And especially, as I told you, the technologies, the telecommunication technologies like 2G, 3G, and 2G has now gone. Now 2G or 3G and 4G or 5G, this is the battleground. So some of the companies like Ericsson or Huawei, these are the companies on the playing ground. So they have the technology. So the developing countries like India definitely they want the technologies. At the same time, this Indian Competition Commission have a fair role to play. But the question is whether they have the expertise to deal with this kind of cases, to deal with the competition law and intellectual property cases. And now, most of these multinational companies are going for global licensing agreements. So these patent infringement suits are only a tool, only in the name of infringement suits. These companies are going on with the Indian partners, compelling them to enter into a global licensing agreements. So actually, these are complete violation of the competition law provisions. So now the IPAB has gone. Now there are high courts and the CCA. And these technology companies, I would say that these technology companies, there must be some guidelines like FTC. There must be some guidelines with regard to the front ends. So what is the reasonable royalty these people can ask for? Not unreasonable royalties. And also these threatening and counter-threatening and cases and the infringement cases. So parties are fed up. So they are delaying the transfer of technology. So most of the cases dealt outside. Most of the cases dealt outside the courts. So I think we can have some time for discussion. So I would say that in the conclusion, there is no conflict. There is no conflict between competition law and IP law in India as well. And the courts, especially I think the Delhi High Court is very active. I would say that overactive in favor of these multinational companies because they are very quick in giving judgments in favor of these multinational companies. So they have to look into the Indian companies as well and also the jurisprudence, looking into the US jurisprudence or EU jurisprudence. Yes, definitely we don't have much cases in India. So they have to look into the Indian provisions and also these jurisprudence from other particular countries. So the IP, as already I said that the IPAB has gone now. So there is no more intellectual property appellate board. Now it is entrusted with the high courts. And there are special benches to deal with the intellectual property board like Delhi High Court. Delhi High Court was already constituted intellectual property bench. So these standard essential patent parameters and guidelines to be drafted by the CCI, the Competition Commission, and the Competition Commission have the full powers to enter into the dominant position of these technology giant multinational companies. So we must control it through the Competition Commission of India. So we have to strengthen the Competition Commission of India with technology people as well as the techno-legal people as well. So as I told you that the competition law needs intellectual property and intellectual property needs the competition law, and it cannot be considered as rivals at all. So we require competition in the market. We require incentives for innovation. Yes, we want innovation in the market. So we provide incentive for innovation. So we have to protect intellectual property. At the same time, if we found that any intellectual property owner is misusing the dominant position, or if they are entering into anti-competitive practices, then definitely we require the competition provisions to curtail this kind of activities. Thank you. I will stop here. I have not touched many areas, but I touched definitely I touched the areas on IP versus competition law. Thank you.
Sir, now I request Professor Reddy sir to please take give.
So thank you very much, Professor Raju. And in fact, it has been a wonderful discourse. I never missed a single word. And now I don't want the participants to lose such, delicious taste of the, admixture of both competition law and intellectual property rights. You touched upon so many issues, including the Micromax, Sony Ericsson, Microsoft. Phenomenal. And it has been a great experience for all of us. We learned a lot of things. And as you rightly said, it is the age of survival of the fittest. So NLUs may have a little advantage, but at the same time, when there is a level playing field, it is only our capacity and the efficiency which will stand us in good spirit, good stand. So thank you very much on my personal behalf. Now a formal vote of thanks, and we wish to have many more such programs. Now over to Mr. Srinivas Rao for a formal vote of thanks. Thank you very much.
Thank you, sir. Thank you, Professor Raju sir, and season's best greetings to you and to all the participants for taking out their precious time to support our endeavor, which is known as Know Your IP weekly lecture series. Sir, we on the behalf of the participants would like to sincerely thank you for your kind presence, and would also like to thank you for elaborating the case laws and putting us forward with your views also. And the benchmark case laws which you have mentioned was informative and worth reviewing once again for achieving the professional expertise in the domain. Specifically, I'm talking about the Micromax versus Ericsson 2016 Delhi High Court, Singhania Partners versus Microsoft, Philips versus Rajesh Bansal. Then you mentioned about FRAND licensing, standard essential patenting. Sir, the rhythm which you have built from CCI to copyrights, performing rights, standard essential patents, technology transfer, that was a fine tune for the today's lecture, sir. And the Monteso case and the limitations also which you have mentioned was also worth researching. So you also mentioned about the pricing, product placement, claiming intellectual property rights both in India and the cross territories. So which was an excellent overview altogether. Thank you for sharing your brilliant wisdom with us, sir. We felt as the time was too less for us to listen to you and we need more time. Nevertheless, we hope to see you once more on a different topic on this platform again. So before leaving, one request to all the first-time participants, that please ensure that you have subscribed to our Telegram channel, which is shared in the link and the chat box, and the YouTube channel to get the regular updates. And on our lecture series, you can view all the recorded videos also. With that note, sir, I hope to see you once again. And now we would like to conclude this session with your kind permission. Thank you, sir. Thank you.
Thank you, Raju sir, and once again I wish all the participants a happy Ugadi, and thank you once again.